Good day everyone, my name is Antoinette Ordinario and this is the continuation of the report of Ms. Janet Ante, the citizenship. So, let's go to the loss and reacquisition of Filipino citizenship. So, citizenship is a political and civil attribute as relevant as freedom of speech, liberty of abode, right against unreasonable searches and seizures, and other basic guarantees of the Bill of Rights. So, unlike the freedoms guaranteed in the Bill of Rights, however, the citizenship may be lost or reacquired in the manner provided by the loss of citizenship may be occasioned by the following acts. First, naturalization under the laws of a foreign country, if one person is born in other country. Second is the renunciation through an act or omission. And third is subscribing to an oath of allegiance to support the constitution or laws of a foreign country. So, kapag nangako ka sa ibang bansa, pag yung loyalty mo ay nakasupport sa ibang bansa. So, being an immigrant in a foreign country does not result in the loss of Filipino citizenships to such immigrant. So, immigration is the act of moving from one place from one another. The act of immigrating, entering into a country with the intention of residing in it. Halimbawa, kung magtatrabaho ka, yan. So, an immigrant is a person who moves into a country for the purpose of permanent residence. So, halimbawa na lang yung 'di ba, yung iba sa Canada, kumukuha sila ng trabaho doon, tapos yung Canada nag-offer sila ng mga residency sa mga taong nag-migrate doon. So, yung iba, una trabaho lang ang pinunta, tapos sunod gusto na pala yung mag-permanent resident. So, unless the immigrant is naturalized in the foreign country, sabi doon, he or she will retain Filipino citizenship. So, likewise, marriage to an alien will not necessarily result in the loss of citizenship. So, Filipino citizens who marry aliens can retain their citizenship unless by their act of omission, they are deemed under the law to have renounced it. So, yung mga nagpakasal sa mga AFAM, so, mariretain pa rin nila yung kanilang citizenship as a Pilipino. So, unless na lang kung i-renounce nila yung citizenship nila dito sa Pilipinas at ang gustong isunod ay yung citizenship ng kanilang mga napangasawa. So, a naturalized Filipino citizen may however lose his citizenship through express of renunciation. So, halimbawa na lang, pag-apply ng Portuguese passport, ng Canadian passport, Saudi Arabian passport, or declaring his nationality as Portuguese in commercial documents. You know? On the other hand, citizenship may be reacquired through 1. First, direct act of Congress. Second, naturalization. 3. Repatriation. So, Filipino women who have lost their citizenship by reason of marriage and natural-born Filipinos who have lost their citizenship on account of political or economic necessity may reacquire their citizenship by taking their oath of allegiance to the Republic of the Philippines. So, yung pag-oath ng kanilang loyalty sa Pilipinas and registering it in the proper civil registry and in the Bureau of Immigration. So, a petition for repatriation shall be filed with the Special Committee on Naturalization at the Office of the Solicitor General upon payment of the kitting fee. So, the question is, can a former Filipino reacquire Filipino citizenship without renouncing his or her foreign citizenship? So, the answer is, yes, this is possible. So, according to the Philippine law, they now allows Filipinos who have become citizens of other countries to apply for dual citizenship. They can reacquire Filipino citizenship while retaining their status as naturalized citizens of the country in which they live. This dual citizenship is not considered as dual allegiance, which is considered inimical to the national interest and shall be dwelt by the law. Let's see to the next topic. So, a dual citizen or immigrant cannot be elected to the public office. So, let's say, for the example, what happened to Miss Grace po, diba? So, parang humarang yung pagiging dual citizenship niya sa pagtakbo niya sa Pilipinas bilang presidente. So, although lost citizenship may be reacquired under the citizenship law, so those who reacquire Filipino citizenship cannot eat their cake and have it too. So they still cannot stand for election to public office in the Philippines unless they renounce their foreign citizenship. So why? So previously for candidates with dual citizenship, it was enough that they elected Philippine citizenship upon the filing of their certificate of candidacy. So to terminate their status as person with dual citizenship, a declaration in the certificate of candidacy that one is a Filipino citizen and that he or she will support and defend the Constitution and will maintain true faith and allegiance thereto, which was under oath operated as an effective renunciation of foreign citizenship. So, dapat kung dual citizen ang isang tao, dapat bago ang certificate, bago magkaroon ng mag-file ng candidacy, dapat ma-renounce mo na yung foreign citizen mo, no? At mangako ka na ito yung susuportahan mo, wala kang dual allegiance ba. So dito ka lang sa Pilipinas, Constitution ng Pilipinas ng ikaw magiging faith and true. However, Republic Act 9225 now provides condition before those who reacquired Filipino citizenship can run for public office in the Philippines. Among this condition is that should one seek elective public office, he or she should first make a personal and sworn renunciation of any and all foreign citizenship before any public officer authorized to administer an oath. So, dapat maalis mo muna yung isang citizenship mo bago ka mag-file ng candidacy. So, bakit kaya? Kasi yung mga dual citizen na yan, halimbawa na lang sa US, yung isang tao pumunta sa US tapos siya ay citizenship doon. So, tapos citizen din siya ng Philippines, dalawa yung magpo-protect sa kanila. Halimbawa, pag ang US, kailangan protektahan ng US yung isang tao, di ba? So, aliens residing in the United States while they are permitted to remain are in general entitled to the protection of the laws with regard to their rights of person and property and to their civil and criminal responsibility. Yun o. Dalawa-dalawa yung kanilang magpoprotekta sa kanila. So, dapat isa lang kasi magkakaroon ng conflict sa batas. So, in general, aliens residing in the US while they are permitted to remain are entitled to the safeguards of the Constitution with regard to the rights of person and property and to their civil and criminal responsibility. Thus, resident aliens are entitled to the benefit of the provision of the 14th Amendment to the Federal Constitution that no state shall deprive any person of life, liberty, or property without due process law, or deny to any person the equal protection of the law, and the protection of this amendment extend to the right to earn a livelihood by following the ordinary occupations of life. So an alien is entitled to the protection of provision of 5th Amendment to Federal Constitution that no person shall be deprived of life, liberty, or property without due process of law. So, in Section 18 in Article 11 of the 1987 Constitution, which provides that any public officer or employee who seeks to change his citizenship or acquire the status of an immigrant of another country during his tenure shall be dwelt by the law. So, it's not applicable to the person who is have dual citizenship for him to acquire the status of an immigrant of the United States before he was elected to public office. Any person who is permanent resident or immigrant to a foreign country shall not be qualified to run for any elective office under this code unless such person has waived his status as permanent resident or immigrant of a foreign country in accordance with the residence requirement provided for in the election laws. Dual citizenship distinguished from dual allegiance. The Supreme Court has fashioned a distinction between dual citizenship and dual allegiance. According to the High Court, the former arises when, as a result of the concurrent application of the different laws of two or more states, a person is simultaneously considered a national by said state. So, for instance, such a situation may arise when a person whose parents are citizens of a state with adheres to the principle of jus sanguinis, like Philippines, is born in a state which follows the doctrine of jus soli, so place of birth. So halimbawa na lang yung nangyari kay Chloe Kaluwag, siya ay dual citizenship dahil yung nanay niya ay pinanganak siya sa US. So yung papa nila at mama niya ay parehong Pilipino. So tayo ay sa principle ng jus sanguinis. Tapos ang US ay sa doktrina nila ay sa jus soli. So siya ay may dual citizenship. Such a person, if sa facto and without any involuntarily act on his part is concurrently considered a citizen of both sides. So yung panganak kay Chloe Kaluwag naman ay involuntary naman yan. Kaya yan ay dual citizenship. Siya ay may dual citizenship. Considering the citizenship clause in Article 4 of our Constitution, it is possible for the following classes of the citizens of the Philippines to possess dual citizenship. So ito yung mga following classes of citizenship na yon. Let's first, those born of Filipino fathers and or mothers in foreign countries which follow the principle of jus soli. So, di ba may mga Pilipino tayong nasa abroad na pinanganak yung kanilang mga anak sa abroad, pero Pinoy pa rin. Yun yung mga salitang dugong Pinoy. So next, those born in Philippines of Filipino mothers and alien fathers, if by the laws of their father countries, the children are citizens of that country. So ito yung mga may half na lahi. Ayan, pwede yan sila dyan magkaroon ng dual citizenship. So, di ba sa Korea, halimbawa, yung napangasawa ng Pinay ay Koreano. So, yung mga bata pinare-register din sa Korea. Third, those who marry aliens if by the laws of the latter's country, the former are considered citizens unless by their act or omission, they are deemed to have renounced Philippine citizenship. So, yung iba, di ba, nagpapakasal dahil gusto ng citizenship sa ibang bansa magkaroon ng green card. So, yung iba, nire-renounce nila yung Philippine citizenship nila. So, there may be other situation in which a citizen of the Philippines may, without performing any act, also be a citizen of another states. But I've said cases are clearly possible given the constitutional provisions on citizenship. So, what is the dual allegiance? So, it refers to the situation in which a person simultaneously owes by some positive act loyalty or two or more states. Dual allegiance, yung pagiging fake ng loyalty ng isang tao, no? Kung gusto niyang magkaroon ng loyalty sa ibang bansa, ganyan, pwede yun. So, iba yun sa dual citizenship. Sa dual citizenship kasi, ano siya, involuntary siya, no? Ito kasi yung dual allegiance, ginusto ng isang tao. Dual citizenship is now allowed by Republic Act number 9225 under Section 3 of Republic Act number 9225. So, in Section 3, retention of Philippine citizenship, any provision of law to the contrary notwithstanding natural-born citizens of the Philippines who have lost their citizenship by reason of their naturalization as citizens of a foreign country are hereby deemed to have reacquired Philippine citizenship upon taking the following oath of allegiance to the Republic. Natural citizens of the Philippines who are, after the effectivity of this act, become citizens of a foreign country shall retain their Philippine citizenship upon taking the aforesaid. It is clear that the intent of the legislator in drafting Republic Act number 9225 is to do away with the provision in Commonwealth Act number 63, which takes away Philippine citizenship from natural-born Filipinos who become naturalized citizens of other countries. At Republic Act number 9225 thus is allowed dual citizenship to natural-born Filipino citizens who have lost Philippine citizenship by reason of their naturalization as citizens of a foreign country. So, on its face, it does not recognize dual allegiance. So, by swearing to the supreme authority of the Republic, the person implicitly renounces his foreign citizenship. So, plainly, from Section 3, Republic Act number 9225, state clear out of the problem of dual allegiance and shifted the burden of confronting the issue of whether or not there is dual allegiance to the concerned foreign country. So, what happens to other citizenship was not made a concern of Republic Act of 9225. The High Court added in that case that in Section 5, Article 4 of the Constitution is a declaration of a policy and it is not self-executing provision. So, the legislature still has no enact the law on dual allegiance. So, in Section 2 and 3 of Republic Act number 9225, the framers were not concerned with dual citizenship per se, but with the status of naturalized citizens who maintain their allegiance to their countries of origin even after their naturalization. Congress was given a mandate to draft a law that would set specific parameters of what really constitute dual allegiance. So, until this is done, it would be premature for the Judicial Department to rule on issues pertaining to dual allegiance. So, let's proceed to civil and political rights and responsibilities of dual citizens. So under Section 5 of Republic Act number 9225, dual citizens enjoy civil and political rights and responsibility. So ito yon. In Section 5, civil and political rights and liabilities, those who retain or reacquire Philippine citizenship under this act shall enjoy full civil and political rights and be subject to all attendant liabilities and responsibilities under existing laws of the Philippines and the following conditions. Those intending to exercise their right of suffrage must meet the requirements under Section 1, Article 5 of the Constitution, Republic Act number 9189, otherwise known as the Overseas Absentee Voting Act of 2003 and other existing laws. So dapat bumoto yung isang tao. Second, those seeking elective public in the Philippines shall meet the qualification for holding such public office as required by the Constitution and existing laws, and at the time of the filing of the certificate of candidacy, make a personal and sworn renunciation of any and all foreign citizenship before any public officer authorized to administer an oath. Third, those appointed to any public office shall subscribe and swear to an oath of allegiance to the Republic of the Philippines and its duly constituted authorities prior to their assumption of office. So provided that they renounce their oath of allegiance to the country where they took that oath. So fourth, those intending to practice their profession in the Philippines shall apply with the proper authority for a license or permit to engage in such practice. Halimbawa na lang yung mga work permit. Fifth, that right to vote or be elected or appointed to any public office in the Philippines cannot be exercised by or extended to or those who first are candidates for or are occupying any public office in the country of which they are naturalized citizens and or are in active service as commissioned or non-commissioned officers in the armed forces of the country which they are naturalized citizens. So next, Statecentric versus Participatory Citizenship. So, the state-centric view holds that the state takes charge and has sole control of the governance processes. It structures political life with minimal participation from societal classes and groups. So, on the other hand, participatory citizenship viewed there is an improvement in the relationship between the state and the citizens. Participation goes beyond voting. It also includes taking part in governance processes. So, participatory citizenship draws its strength from democratic constitution, where the rights and freedom that accompany citizenship include the right to participate in governance. So, the 1987 Constitution, for all its verbosity, institutionalized participatory citizenship in Article 13 aptly titled Justice and Human Rights, and Article 13 contains these provisions. So, the role and rights of people's organization. In Section 15, the state shall respect the role of independent people's organizations to enable the people to pursue and protect within the democratic framework their legitimate and collective interests and aspirations through peaceful and lawful means. People organizations are bona fide associations of citizens with demonstrated capacity to promote the public interest and with identifiable leadership, membership, and structure. The vibrancy of a state and its capacity to withstand economic and political turmoil rests on involved citizenry, which is envisioned in the preceding provisions. With everyone having a stake in good governance, the road to progress cannot be far. Power will be diffuse. The shared responsibility will ensure benefits for all and not just for the privileged few. Economic wealth will be distributed equitably. The invisible barriers of inequality in political and economic life will consequently disappear. That's all. Thank you.